You are just walking out of a convenience store, holding a soda, or maybe you're minding your own business at a public park. Out of nowhere, a police cruiser pulls up, an officer steps out, walks straight toward you, and says, "Hey man, do me a favor and show me your driver's license." Your stomach ties itself in knots. You haven't done anything wrong. So why are they asking? Your brain tells you that if you just comply, they'll leave you alone. But what if I told you that handing over that little piece of plastic is actually a legal trap? What if I told you that by being polite, you might be giving up the exact constitutional rights that protect your freedom? In this video, I am breaking down the hidden psychology behind police ID checks, the massive mistakes 90% of citizens make, and the exact, legally binding script you need to use to control the situation and protect yourself. Let's get one thing straight right out of the gate. Police officers are absolute masters of conversation. They are highly trained in what the legal system calls consensual encounters. A consensual encounter is just a fancy way of saying a voluntary conversation. If an officer walks up to you and says, "Hey, can I talk to you for a second?" or "Do you have an ID on you?" they are not ordering you to do anything. Legally, they are making a request. They are treating you just like a regular person asking for directions. But because they are wearing a badge, a gun, and a uniform, your brain registers the request as an absolute command. And that is exactly what they are counting on. They want you to voluntarily hand over your rights without them ever having to force you. Now, why do they want your ID so badly? It's not because they just want to know your name. The moment that card touches the officer's hand, the entire dynamic of the interaction changes. They walk back to their patrol car, open up their computer, and they start a fishing expedition. They run your name for outstanding warrants. They look at your past criminal history. They check if your address matches, and they check if you have any association with anyone else they are investigating. What started as a simple, innocent walk down the sidewalk has now turned into an active background investigation. And here is the kicker: you authorized it. By handing over that ID willingly, you legally consented to the check, which means you cannot challenge it later in a court of law. So, let's talk about the actual law. What does the U.S. Constitution say about this? Under the Fourth Amendment, you have a right to be free from unreasonable searches and seizures. For a police officer to legally stop you and demand your identification, they cannot just have a gut feeling or a hunch. They must meet a legal standard known as reasonable suspicion. This comes from the landmark Supreme Court case Terry v. Ohio. Reasonable suspicion means the officer must be able to point to specific, objective, and observable facts that connect you to a specific crime that has happened, is happening, or is about to happen. For example, if a bank was just robbed 2 minutes ago by a guy in a red hoodie, and you are running down the street 2 blocks away wearing a red hoodie, that is reasonable suspicion. But if you are just walking down the street looking suspicious or hanging out in a high crime area, the Supreme Court has ruled time and time again that this is absolutely not enough to force you to identify yourself. But what about stop and ID states? You've probably heard this term thrown around a lot on the internet. Yes, about half the states in America have passed local laws called stop and ID statutes. But people completely misunderstand these laws. A stop and ID law does not mean the police can just walk up to random people on the street and demand their papers. The law explicitly states that the officer must already have a valid, lawful detention based on reasonable suspicion before the ID law even kicks in. If there is no reasonable suspicion of a crime, the stop and ID law is completely useless. Furthermore, another major Supreme Court case, Hybel v. Nevada, clarified that even when a state law requires you to identify yourself, you generally only have to state your name verbally. The law does not require you to carry or produce a physical driver's license unless you are operating a motor vehicle. So, how do you handle this out in the real world without starting a fight, but without giving up your rights? You use a precise legal script that forces the officer to put their cards on the table. The very first words out of your mouth should be, "Officer, am I being detained, or am I free to go?" Do not be rude, do not yell, and do not argue. Just ask the question clearly. This single phrase draws a legal line in the sand. If the officer says, "You're free to go," then the conversation is over. You can say, "Have a nice day," and walk away immediately. You do not have to answer another question, and you definitely do not have to show an ID. But what if they say, "No, you're not free to go, you are being detained"? Now you know they are claiming to have a valid Terry stop. Your very next question must be, what is your reasonable suspicion? What crime do you suspect me of committing? This forces the officer to state their legal justification out loud, which is critical because their dashboard camera or body camera is recording everything. If they say something vague like, "Well, we got a call about someone matching your description," or "You just look out of place," you now know that the stop is legally weak. If you are in a stop and ID state, and they have stated a reason, you state your legal name clearly and verbally. "My name is," your name. That is your maximum legal obligation. If they demand the physical card, you calmly state, "I have identified myself verbally as required by law, and I am not required to present a physical ID card as a pedestrian." Now, let's talk about the absolute worst case scenario. What if you get an aggressive officer who completely ignores the law, gets angry, and threatens to arrest you if you don't hand over your physical license. This is where many people make a fatal mistake. They start arguing, resisting, or pulling away. Never do that. You will never win a legal argument on the side of the road with a cop who has a gun and handcuffs. You win that argument later in a courtroom. If the officer escalates and threatens arrest, you protect yourself by stating your final script clearly for the body camera. I am not resisting you, and I will comply with your physical commands, but I do not consent to any searches or seizures, and I am exercising my right to remain silent. By saying this, you are preserving your rights for later. If that officer arrests you or forces a search without a real legal basis, your lawyer can use the recorded footage to get the entire case thrown out of court, and you may even have the grounds to file a federal civil rights lawsuit for unlawful detention. The bottom line is this: your rights only protect you if you actually know how to use them. The legal system relies heavily on implied consent, meaning if you don't speak up an object, the law assumes you are perfectly fine with what is happening. Don't fall into the politeness trap. Be respectful, stay perfectly calm, but stand firm on your constitutional rights. If you found this breakdown valuable and want to know more about how to navigate these tough situations, make sure to smash that like button, subscribe to the channel, and share this video with your friends and family. Knowledge is power. Stay safe, stay smart, and I'll see you in the next video.